Hello aspirants, welcome back to Believers IAS Academy. In today's video, we will be continuing the emergency provisions, one of the important chapter from Lakshmikant, as a part of Prelims high yielding topic discussion for the Prelims 2026. So let's start from the question number 11. So yesterday we had covered but about 10 questions from the emergency provisions, which covered some of the very important topics. And today we will be starting with the question number 11, which talks about the national emergency and also a little bit about the precedent rule in detail. So let's start. So during a national emergency, can the president promulgate ordinances on matters in the state list? So the answer is yes. During a national emergency, Article 352, the legislative competence of a parliament expands even to the state legislatures, and under Article 353b, Parliament acquires the power to legislate on subjects in the state list as well, and per se, state legislature need not be suspended. Okay, this is one important thing to keep in mind. State legislature stays active, it need not be suspended, but Parliament can acquire the power to legislate on the subjects mentioned in the state list. And since the president issues ordinances, and which is the article 1, 2, 3, very important. This is the ordinance power of the president, and the president, since issues ordinance on matters where parliament can legislate, this power also extends to stateless subjects also during emergency. So both president and even parliament can legislate on behalf of the state legislature during the national emergency, and the president in the form of ordinances. And what is the article 123, and the parliament with respect to article 353b acquires the power or assumes the power of the state legislature to make laws on the subjects mentioned in the state list. So the president can promulgate ordinances on state list matters during national emergency also, and these ordinances, very important, remain subject to parliamentary approval once parliament reconvenes. So let's say parliament is not in session, but an urgent importance, or let's say a matter of urgent importance, has to be administered. So the president issues ordinances and he legislates in the form of ordinances, and that time the parliament might not be in the session, and later, after when the parliament reconvenes, it has to be approved by the parliament, or like for that matter the Lok Sabha. Now the next question is, can the term of Lok Sabha be extended during a national emergency? The answer is yes. Article is 83. So the parliament may extend the life of Lok Sabha, but 1 year at a time. This is very important, and this extension can occur only during a national emergency. And very important thing you have to keep in mind, that this extension cannot go beyond 6 months after the emergency ends. Means after emergency, the extension period, like it cannot go beyond 6 months. And this is very important. Why? Because this was brought in, like especially the extension of the life of Lok Sabha by 1 year at a time. The whole purpose of this was to make sure that it can pretty much avoid conducting general elections during an extraordinary situation like a national crisis, and the example is 1975 emergency. Next question, what are the constitutional provisions under Article 358 and 359 regarding fundamental rights during national emergency? And how did the 44th Amendment modify them? Very, very important, because Article 358 talks about the suspension of Article 19, and Article 359 talks about the suspension of enforcement of certain fundamental rights. So what is Article 358? Now there are three important points. It automatically suspends fundamental rights under Article 19, very important. And this applies only when emergency is declared due to war or external aggression, and not of internal aggression or internal disturbances. Very, very important. And even if it is financial emergency, even then it is not suspended. And Article 358 can be let's say invoked, or let's say the suspension of Article 19 is only possible when emergency is declared due to war and external aggression. Government can make laws inconsistent with Article 19 as well. So when the government, when making laws, it need not try to safeguard your fundamental right ensured under Article 19. So what are the changes after the 44th Amendment Act 1978? So made sure that the Article 19 suspension no longer apply during armed rebellion emergency. That is also one important thing. And the protection of civil liberties were also strengthened. So, however, the first point is very important, that the suspension of Article 19 was no longer made applicable to armed rebellion or any internal emergency. Next is Article 359, which talks about the suspension of enforcement of fundamental rights. So here, the president may suspend the right to move for courts for enforcement of certain fundamental rights, and this suspension applies only to rights specifically mentioned in the presidential order. So this could be anything, and this, depending on the situation, the president time and again, he would give a presidential order which states that these particular fundamental rights can be suspended. And the safeguard for the 44th from the 44th Amendment was that Article 20, especially the protection in criminal cases, and Article 21 was made absolutely protective. Means Article 20 and Article 29 were made never to be suspended, right? It cannot be suspended even during emergency, any emergency for that matter, right? So Article 20 and 21, they were given the immunity, especially during emergency, and this immunity was given by the 44th Amendment Act. 14th question, distinguish between Article 358 and 359. So now what are the differences? So there are 6 to 7 important differences. So the first one, Article 358, it suspends fundamental rights themselves, right? Whereas Article 359 suspends only on the right to enforce them in the code. So you have to understand that Article 358, it directly, right, it does not need any particular law and order for that matter. Article 358 directly suspends the fundamental rights themselves, whereas the 359, it suspends only the right to enforce them in the court. So the article per se is not suspended, but rather the need to go to the court. Let's say a fundamental right, let's say Article 19 is suspended, or let's say Article 22 is suspended. So per se, under Article 359 doesn't mean Article 22 is suspended all of a sudden. It only means that if a person is violated by, let's say Article 22 of a particular person is violated, now he cannot go to the court. So the move, or the person which earlier he could have gone to the court to enforce his right, that particular right itself is, only curtailed, is what Article 359 talks about. Next, Article 358 applies only to Article 19, very important, whereas 359 may apply to multiple fundamental rights. Very, very important. Next is Article 358. It operates automatically after emergency proclamation, whereas Article 359 requires a separate presidential order. So 358 does not require any prior law, or let's say doesn't require any invocation separately. The moment national emergency, or any emergency for that matter, the emergency based on war or external aggression is let's say proclaimed, Article 358 comes into the picture, whereas Article 359 needs a separate presidential order which states which are the fundamental rights that can be suspended. Article 358 applies only in cases of war or external aggression, but however, 359, it applies for any type of national emergency. Then 358, it allows laws inconsistent with Article 19, whereas Article 359 does not invalidate rights but only restricts the judicial remedies, right? Right to move to the court is only curtailed, right? That is one more important thing. Article 358, it protects post-emergency revival of rights but validates emergency laws, whereas 359 merely suspends the enforcement temporarily. Pretty much one and the same thing. And the last one is Article 358. It affects the citizens' freedom under Article 19, but 359, it affects the judicial protection mechanisms, because now right to move to the court itself is blocked, right? So that is also one important thing. And these 7 points are absolutely important, very, very important. Next, in terms of similarities, there are two important similarities, that both, the Article 358 and 359 operate only during a national emergency, not any normal circumstances. And also both expand the executive and the legislative powers of the government during the crisis situation, especially to the states. Next question, how many times has national emergency been declared in India? So there have been 3 instances: 1962 during Sino-Indian War, the India-China famous war where India lost, and 1971, the India-Pakistan war, and 1975 due to because of an internal disturbance which caused the disruption. And these were the 3 instances where national emergency was proclaimed. And one important point to keep in mind, that the first two emergencies, especially 1962 and 1971, were due to external aggression because of war. Of course, but the third one was due to the internal conditions, stating Indira Gandhi's election problem, and the Allahabad court verdict and all of that. Next article, the question number 16. Under which articles is President's rule proclaimed? Can the President impose it without a governor's report? So now very, very important President rule. So it is proclaimed under two important articles. One is 356. This is due to failure of constitutional machinery in a state. Fair example is your Manipur, and 365 failure of a state to comply with the union direction. So these are two different things, two different articles, but both of these will give rise to president rule. So president usually acts on the governor's report, pretty much like Manipur. Even the governor of Manipur gave it a report writing stating that the state constitutional machinery has failed, and hence the president rule was invoked. It was under president rule for a very long time, and very recently, February, it was invoked. I mean, removed. It was invoked back, and the new chief minister has also been commissioned. So, in fact, yeah, a lot of things have happened. Anyway, it's good, and also from the current affairs point of view, it's better you go through about the president rule with respect to Manipur as well. However, Constitution allows President to act even without the governor's report if sufficient information is available. From the prelims point of view, this is also important. So, governor report as such is not mandatory. Next question: what is the procedure for parliamentary approval and during the what is the procedure for parliamentary approval and duration of president's rule, and what safeguards were added by 44th Amendment? So parliamentary approval. So for proclamation, it must be approved by both the houses, the Lok Sabha and the Rajya Sabha of the Parliament, within 2 months. And once approved, the president rule continues for the 6 months, right? And also the maximum duration for the president rule can be can be extended up to 3 years, subject to conditions. And what are the conditions for the extension beyond 1 year? So first is the national emergency must be in operation in the whole or any part of the state. And next is the election commission report, which certifies that the elections cannot be held in that particular state. So this is to safeguard this, or let's say, it pretty much safeguards the strengthened and, it safeguards and also strengthens the constitutional reforms that has been brought to make sure that the misuse of this super extraordinary power, so what is so called as the president rule, is not happened. Next is 18th question: what happens to the state executive and the legislature during the president rule, and who passes laws and the state budget? So in terms of the executive, the state council of ministers is absolutely, they've dismissed. Governor administers the state on behalf of the president. And in terms of the legislature, so you have to keep in mind that the legislature, either it is suspended or dissolved. But on the other hand, during national emergency, it is not suspended, but it stays to remain in function. But however, Parliament will take over in terms of legislation. And next one, in terms of lawmaking authority, Parliament assumes legislative powers of the state. This is we are talking about president rule. And next is with respect to budget and bills. Parliament passes the state budget, and also it delegates this authority to the president or another authority as well. So next one is, do laws and made during president's rule expire after it ends? What is the status of the High Court? So the question is simple. It is asking if president rule is coterminous or not. So answer: validity of laws, especially the laws which were made during the president rule, they do not automatically cease. Very much important. They do not automatically cease after it ends. However, they remain valid until amended or repealed by the state legislature themselves. Very good example is Manipur. So I think just now during February 2026, the president rule was removed and the new chief minister has also been appointed. So for more details about how is the situation, it's better you go check the condition of Manipur as to how it is doing currently, and you think you will pretty much get a fair idea. Next, with respect to status of High Court, very, very important. What happens to the judiciary, especially the High Court? So they absolutely remain unaffected, and the powers and jurisdiction also remains intact, especially with respect to the judiciary and also the High Court, one and the same. So this also to ensure judicial independence even during president rule. Next, 20th and last question: can Parliament legislate on stateless subjects during national emergency and president's rule? Well, during national emergency, Parliament acquires the power to legislate on the stateless subjects that we all know, and state legislatures continue to exist. Right? They do not get dissolved, or they do not stay inactive, but they continue to exist. But Parliament's power overrides in terms of making laws in all the areas which are mentioned in stateless subjects. Next, during the president's rule, Parliament assumes the legislative powers because the state legislature is suspended or dissolved. So here we have to keep in mind the state legislature is dissolved, because the president rule in the first place is invoked only because if the state machinery, let's say the constitutional machinery in that particular state has failed, right? So it means state legislature, they will not be in function. So the moment you just understand that logic, it's very easy to understand. And parliament legislates on behalf of the state even during the president rule, and even president can also legislate through ordinances. What are the key differences? The national emergency, under which both parliament and the state legislature may function. However, overriding power will stay with the parliament. And during the president's rule, the parliament legislates in the place of state legislature. Right. So that's all about today's video. We've discussed 10 most important topics. I wouldn't say questions, but 10 most important topics. So that's all for this particular video. I hope you have liked the video. So follow us and stay tuned with more such videos which keeps coming. And all the best for your prelims 2026. Signing off, this is Madan Gopal. Have a wonderful day.